Buncombe County Board of Adjustment meeting is now called to order. Let's go ahead and start with introducing everybody, and then we'll get through some housekeeping matters. Let's start from the left.
Michael Buncombe.
Wendell Howard. Tom Chris. Keith Levi.
Andy Ball.
George Lycan.
Martin Moore.
Dot Cordell.
Robbie Taylor.
County Staff, Planning Director.
Brandon Freeman, Buncombe County Legal Department.
Michael Frew, County Legal.
Haley Matfest, Planning.
Joshua Freeman, Planning.
All right, thank you all for being here today. We're going to start off with Director Pennington reading some logistics into the record here.
Good afternoon, Mr. Chair, board members, and members of the public. Just a couple of housekeeping matters and orders of procedure. Bathrooms out this main door to the left. Public restrooms are available. We have an overflow room downstairs on the first floor due to obvious interest in a number of projects, specifically Crossroads today. Staff will be working to move appropriate parties back and forth based on the agenda items. I would like to note, if you are parked in the TD Bank parking lot, please move your car or they will move it for you. Microphones for all the people sitting on the dais today, they toggle back and forth. It's probably the best interest to just go ahead and leave them on green since we're now in the public hearing itself. I'd ask that we please observe board rules as Chair Moore will lay out here momentarily. Mainly speaking, refrain from any outbursts, clapping, props, and signs. Please note that the Buncombe County Board of Adjustment makes decisions on development applications based on quasi-judicial procedures. These are somewhat similar to rules followed by courts of law. Because of this structure, the board is held to strict standards as it relates to their evaluation of applications. The board's decision may not be driven by arbitrary or unqualified opinions, fears, or hearsay, but is determined by factual evidence based on exhibits, testimony, and expert witnesses. Board of Adjustment members are discouraged from speaking to members of the public ahead of the hearing and must disclose any such conversations at the hearing. These conversations are referred to as ex parte communications and may have an impact on the board members' ability to participate in the hearing. The conditional use process differs from other local governments, but it is not uncommon and is widely used across the state of North Carolina and throughout the United States. While community members and organizations may participate in the hearing, it is important to note that any testimony given must be sworn, relevant, non-repetitive, and factual. If you speak today, you must be sworn. Opinion evidence may only be given by qualified experts. I'd like to acknowledge there are a number of staff present today. We have subject matter experts from the staff that represent stormwater, erosion control, parks and recreation, planning. The staff's role is to present the facts of the case to the board, as well as a list of proposed conditions that the board may consider as part of their deliberation of the case. These conditions may be accepted, rejected, added to, or revised, but must be accepted by the applicant should the project be approved. The planning staff does not issue a recommendation as to approve or deny the project. The determination lies with the Board of Adjustment based on findings of fact. There are outside agencies present today as well, and as we move through the hearing, they will make themselves known. Specifically speaking, Mr. Chair, I'd like to note that the North Carolina Department of Transportation, as well as some staff members from the City of Asheville, are present. And if there's anyone else present from an outside agency, you may be asked to introduce yourself as we move through the hearing. That being said, that concludes my opening remarks.
Thank you very much, Director. Okay, do we have any disclosures of ex parte communications or conflicts of interest that have arisen since our last venture here? All right, seeing none. Has everyone had an opportunity to review the November 13th minutes?
Yes.
Make a motion to approve as submitted.
Second.
I have a motion and a second. All in favor of approving the November 13th minutes?
Aye.
Any opposed? Thank you. All right. So welcome. This is probably going to be hopefully the last untraditional meeting like this for quite some time, at least the last one of this year. Welcome everybody from the community, attorneys on both sides, and all members who are here as experts. We thank you for your time. This, as Mr. Pennington said, is a quasi-judicial evidentiary hearing. It means similar to a courtroom, state and local law set specific procedures and rules on how this board must make its decisions. Our discretion is limited. We base our decisions on the competent evidence in the record, mostly things, the only things that are substantial and relevant and properly offered into the record. Our decisions are constrained by the standards in the zoning ordinance and based on the facts presented. If you'll be speaking as a witness today, please focus on the facts and standards, not your personal preference or opinion. Personal knowledge is fine. Speculation on things such as traffic, impact on the community, crime would be inappropriate for most witnesses. We value a transparent process and encourage everyone in the community to remain engaged and participate, but given this is a hearing on the record, there are certain topics and areas that limit the type of testimony that we can receive from specific people in the community without asserting standing. For those of us who had the pleasure of being here last session, we had a very long discussion about standing, and we'll address that prior to the specific projects. But I will provide ample opportunity for anybody else to assert that, though I think both sides would probably agree for our main project today that that's adequately addressed at this point. Is that fair? We have a few projects on today, only one of which is marked last, not to be continued again. However, it was brought to my attention by staff that the Enka Candler Fire and Rescue Department is here and kind of has a non-negotiable. Can I see a show of hands for anyone who's here for that project? I see all of 3 people here. I'm guessing most of you are here for something else. Unless somebody on the board has an objection, I would like to hear that one first. It seems rather essential and shouldn't take very long. The attorneys are agreeable as well?
Yes.
Okay. If we can start with introducing that project first. Mr. Freeman.
Yes, sir. Bear with me one moment while I pull up the site plan here. All right, and I apologize for the board's benefit in particular. The screen that you have is, we're having some audio visual issues, so this is about as good as we can get. And we appreciate all the work that the IT staff has been, and communication staff has been doing to make all this work for us. All right, so this case is case number 2019-50. The applicant is the Enka Candler Fire Department, represented by Mr. Michael Goforth, civil engineer who just had a seat at the front of the room. The applicant, the agent is Mr. Goforth. The applicant is Mr. Howard Beddingfield. The subject property is 23. The project area is 3 acres. Maximum elevation is right at 2,000 feet above sea level. 19% slope across the property. The use of the land as proposed is a fire station. There's also a school on the same property. The utilities are provided by MSD and City of Asheville. I will note that this public hearing was properly advertised in accordance with the general statutes and Buncombe County Code. I would ask the board to accept staff's and the applicant's materials into the record as evidence. The specific request before you, the applicant is seeking a 10-foot front yard setback variance from a total of, so the setback is 20 feet from the edge of the road right-of-way. I'll show you on the site plan specifically what I'm talking about. The applicant's asking for a 10-foot variance from that setback. So on the screen, as you can see here, this is the footprint of the proposed fire station, and the setback variance would be from the edge of this public street. 20-foot setback. The applicant needs to be able to move 10 foot into that setback due to a conflict with utilities. With that, I'll take any questions and then turn it over to the applicant for his presentation.
Are there any questions from board? We will so admit the report and staff recommendations. Thank you. If we can have the applicant be sworn in. Staff, please.
Raise your right hand. State your name.
Michael Goforth.
Do you swear or affirm to tell the truth and nothing but the truth?
Good afternoon, Board. Thank you very much for allowing us to go first. I really appreciate and respect all the time of everyone behind me. We are building a new fire station for the Inca Cameron Fire District. It's on the it's on the property that's owned by Buncombe County. There's already the Inca Intermediate School that's there currently. We are requesting a reduced setback on the front. On Jacob Home Way, which is the front side of our building, there's a 60-foot right-of-way, and then we have a 20-foot setback on that. We are requesting to reduce that to 10 feet to allow us to slide the building a little bit closer to Jacob Home Way. That will still put us close to 20 feet from the edge of pavement there. So we're still going to be pretty far back off the edge of pavement, and it won't be uptight or anything like that next to the road or anything. The reason we're requesting this is because on the rear of our site, we have a 70-foot transmission line from Duke Power that is non-negotiable. Can't move that. They won't allow us to do very much in that right-of-way as far as grading, parking, anything like that. In addition, there's another three-phase power line that's right outside of that 70-foot transmission line easement. So we're pretty hemmed in with that site to make a fire station work. As we all know, fire trucks require a pretty large turning radius. They're long axle trucks. We need a little more space to make that work. And then plus just the needs of building a fire station, sleeping quarters, cooking, things like that a typical fire station needs. So that's our request, to shorten that front yard setback.
Thank you, sir. Any board questions for the applicant? Is there anyone here present to speak in favor or against this project? All right. You may make a closing statement. You don't have to.
I have nothing else to add.
Thank you. All right, we'll go ahead and close the public phase of this portion of the hearing. Any board commentary, motions at this time?
Mr. Chair, based on the evidence presented to this board, including the following exhibits: the petitioner's application, the submitted development plan, the GIS maps, the staff report, the findings of fact worksheet, and testimony presented at this hearing, I move that this board adopt the following findings of fact, 1 through 7, 8A inclusive.
Second.
I have a motion and a second on the findings of fact as read. All in favor of adopting the findings of fact?
Aye.
Any opposed? Those are so adopted.
Mr. Chairman, based on the foregoing findings of fact and for the reasons set forth therein, I move that the requested variance be approved.
Second.
I have a motion and a second on accepting the application and be for its approval. All in favor?
Aye.
Any opposed? That is so approved. Thank you very much. Good luck.
Thank you very much.
All right. Does the board have any preference on the next project? I don't, can we get a feel for who's here for project 51? That would be the conditional use permit for Barry Garns, the vacation rental complex. Okay. I'll invite input from the board. I think, do that one as well. Is Savannah?
She's on her way up, and
On her way.
I need to transfer some materials over, so just one moment.
Is that unanimous from the board? Address this one first.
With a reminder that we will adhere strictly to the rules of evidence on this.
Agreed. And as a reminder, as staff works their way up from downstairs, we are only going to consider evidence properly admitted. That means that phones, signs, outbursts, anything to try to gather the attention of the board would not be considered and would be inappropriate and detracts from our valid consideration of the project. I believe we are ready to introduce that one.
Mr. Chair.
Yes.
One moment, I'm sorry. I'm trying to navigate
Mr.
between-
Chair.
Yes, sir.
Will they need our spots? Would that be helpful?
Most likely, if you don't mind.
Can I make an announcement about cars about to be towed?
Please.
Okay. An Explorer with the tags PKB 3973, a Ford Excursion with the tags DJP 4277. You have 15 minutes if you're parked at the bank.
Strong suggestion you not chance it. They will tow you. All right. If we can have the applicant step up for Barry Garn's application, ZPH 2019-51. Stand by for 1 second. We're going to introduce the project. Savannah.
Okay. State your name.
Barry Garnes.
Oh, sorry. I'm swearing in staff right now.
I'm sorry.
Okay. Raise your right hand. State your name.
Savannah Gibson.
Do you swear or affirm to tell the truth and nothing but the truth?
I do. All right, so good morning, Mr. Chair and board members. My name is Savannah Gibson. I'm a planner with the Buncombe County Planning Department. Microphone. Thank you. Is that better? Okay. I'll start over. Good morning, Mr. Chair and board members. My name is Savannah Gibson, and I'm a planner with the Buncombe County Planning Department. I'm here to present ZPH 2019-51. And let me begin by stating for the record that this public hearing was properly advertised in accordance with North Carolina General Statutes and Buncombe County Code. Secondly, I respectfully request that staff report and applicant materials be accepted into the record as evidence.
My discretion, that's so admitted.
Okay. So this case, ZPH 2019-51, Barry Garnes, the property owner at 500 Reeves Cove Road, which the site plan is pulled up. PIN number 9616005255 is seeking approval for a conditional use permit for a 6-unit vacation rental complex. The project will be served by well and septic, and the parcel is zoned open use. Speaking to the conditional use permit standards, the proposed vacation rentals will operate in a previously approved manufactured home park, which is a permitted use in open use. Vacation rental complexes are also an allowed use in open use zone districts. The owners will closely monitor the property since they live on the property full-time. The surrounding uses of land consist of single-family residential, stick-built, and manufactured units. The proposed use is located outside of any flood areas as well as outside of any steep slope, high elevation, or protected ridge overlay districts. These 6 units are spread over 8.25 acres, with the natural setting being as undisturbed as possible. The proposed density and use comply with this open use zoning district, with noise being enforced by the owners during quiet time, which they propose from 10 p.m. to 7 a.m., again, as indicated in the applicant narrative. And buildings will be 1,200 square feet on a rock foundation with a covered porch. Per vacation rental standards, the minimum distance between buildings will be 20 feet per the site plan provided. The applicant indicated that each unit will have parking for at least 3 vehicles, which exceeds the parking requirements for vacation rentals, which is 1 space per 2 guest rooms. There will be no on-premise signs proposed at this time. And bathroom requirements will also be met, with each unit having 2 bathrooms for 3 bedrooms. And again, that rule is 1 bathroom must be provided for every 4 guest rooms. Staff recommends approval with the following conditions: an approved erosion control plan from Buncombe County, as well as an approved stormwater plan. And per the conditional use standards, an NCDOT driveway permit will be required prior to the issuance of any zoning permit for the vacation rentals. Upon issuance of any certificates of occupancy, the parking spaces proposed must be checked for compliance. And again, the owner indicated in his narrative that he meets these standards. Septic and well permits must be approved by the Buncombe County Environmental Health before construction can begin on any unit. And staff suggests also as a condition of approval that existing vegetation remain along property lines closest to the complex in order to facilitate an appropriate separation from dissimilar adjacent units. Provided that these conditions are enacted, the applicant does meet all requirements of the zoning ordinance of Buncombe County. Thank you.
Any questions for staff? Thank you, and notate your recommendation and accept your report into the record. If we can have the applicant stand and be sworn in.
Raise your right hand. State your name.
Barry Garnes.
Do you swear or affirm to tell the truth and nothing but the truth?
I do.
You may begin, Mr. Grimes.
Basically, it's just a 6-unit, Savannah basically give all the details of the project. We're going to leave all the vegetation there. This is not a high-density project. It's a very low-density project with a cabin feel in the woods. It's really, it's on our personal property, so, you know, it'll be monitored closely to where that there's no issues with that. So, you know, Savannah basically covered most of the properties of the project.
Does the board have any questions for the applicant? Seeing none. Are there any members of the community here to speak for or against this project? Yes, ma'am, if you don't mind stepping up, please. I'm just going to have you take the microphone on my right, or the public comment one works too, if you'd like to speak there.
My name is Michelle Bretz. I
Oh,
live.
sorry,
one
to be
moment.
sworn in.
Yes,
Yeah.
that's what I'm saying. My name is Michelle Bretz, and
Okay.
I swear.
Oh, okay. Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Great.
I actually live in the subdivision directly behind in Wynwood Park. I have a question because it's not written in our covenants, but how are we supposed to be able to get up to the road? Because I looked at the area in here. It was never explained to me when I purchased my house about this road that we share in common with your property.
May I answer that question? The actual right-of-way for the road, Windy Park Way, is actually on my property. The Windy Park Development actually has right-of-way to access that across my property. But the drive itself is actually located on the western side of my property.
Okay. Would you be willing to come to the homeowners association meeting and talking to the rest of the residents about what your proposals are?
Absolutely.
Okay. And, those were basically my two concerns.
Thank you, ma'am. Are there any other parties with an interest? If you'd like to step up, sir. If you don't mind standing near the microphone, say your name and you'll be sworn in by Haley.
Yeah, I'm Bruce Johnson, one of the residents of Windy Parkway.
Repeat your name.
Bruce Johnson?
Bruce Johnson. Do you swear or affirm to tell the truth and nothing but the truth?
Yes. And I just have a question for Barry. Barry's been a great neighbor to us. I'm in the subdivision right above his property. I just want to know what else is planned for the vacation rental complex besides just the cabins?
Nothing, just the stormwater provisions and things like that, so there's
Okay.
nothing else planned.
Is anything else granted by giving him a vacation rental complex? It sounds like it could be a big deal. I mean, I don't know.
No, sir, it would just be the approval of the vacation rental complex.
Just the cabins?
Yes.
Okay, all right, thanks.
Thank you.
Okay. I will clarify that any additional units would have to come back before the board.
Is there any other comment from the public as to this project specifically? You may make a closing statement. You do not have to.
Thank you.
I've got a question about, is it totally clear that the residents that have been using that road can continue?
Excuse me, George, what was the question?
The residents that are, like the lady previously, would it be, is it totally clear that they can continue to use the road?
Yes, it's a
access?
deeded right-of-way, and this does not affect the deeded right-of-way whatsoever.
Okay.
It's totally a separate, but it does access the actual main road through their deeded right-of-way, so my project will eventually, does tie into that, so. If you look on the western side of the development on the site plan that I give you guys, the Windy Parkway is not marked on there, but it actually runs along the western side of that, that site plan. And then that, in turn, runs into Reeves Cove, which is a publicly maintained road.
Thank you.
At this time, we'll close the public phase of this hearing. I'll invite any board statements or input. Otherwise, I'll entertain a motion.
Mr. Chair, based upon the evidence presented to this board, including the following exhibits, the petitioner's application, the submitted development plan, the GIS maps, the staff report, the findings of fact worksheet, the testimony presented at this hearing, I move that this board adopt the following findings of fact, 1 through 7, A inclusive.
I have a motion.
Second?
I have a motion and a second. All in favor of adopting the findings of fact as stated?
Aye.
Aye.
Any opposed? Those are so adopted.
Mr. Chair, based upon the foregoing findings of fact and for the reasons set forth therein, I move that the requested conditional use permit be approved.
Second?
I have a motion and a second to approve this project, ZPH 1951. All in favor?
Aye.
Any opposed? That is so approved. Thank you very much, sir. While staff transitions for the next project, I'll just offer as a reminder, for certain topics, this board needs to hear opinion testimony from experts. These expert witnesses are going to be appropriately entered if we consider any testimony from them whatsoever. Sometimes that includes information about traffic studies, impacts on the community. Individuals providing expert testimony must be qualified and must provide the factual evidence upon which they base their expert opinions. For the public, and in layperson's term, that essentially means unless you're an expert and you're tendered as an expert and can back those credentials up under the legal standard, we're generally not going to hear opinion testimony beyond personal knowledge and specific things that you know to be fact and have specific personal knowledge on. With that in mind, is staff prepared for the next project?
Yes, sir. In 30 seconds or less.
Right. And as a housekeeping issue, since we had so much fun last time, is there anyone else here to assert standing?
Mr. Chair, we have, at the last hearing, I'll stay seated, I know I have that tendency. We talked about Jesse Corpening. At the last hearing, we had talked about Jesse Corpening and offered an affidavit in support of that. The board did not take that issue up. It voted to find standing for the other 3 clients, but did not vote one way or the other related to Ms. Corpening's property. Her son, Bennett Corpening, is here today, and we plan on submitting him for standing for the board's consideration related to that property because he was not able to attend the last meeting.
Okay. And I suppose now is as good a time as any to address the standing issue. Just so we're clear, this board has made a determination as to standing. Mr. Levi made a motion to find that the city of Asheville had standing, represented by Mr. Edgerton, who is present. That motion passed unanimously. Mr. Chris made a motion to find standing for Ms. Tara Warren.
Yeah, they just never acted on it.
That motion passed unanimously. Mr. Chris made a motion to find standing for Ms. Kate Millar. That motion passed unanimously. And we also found standing for Ms. Jolene Elkins, and that passed unanimously. That is correct. We did not make a determination as to Ms. Corpening. If you'd like to do that beforehand, we can do that with the consent of opposing counsel. Otherwise, you can make that part of your presentation in chief.
Whichever way you'd like, Bob. I did want to clarify, Miss Millar was both individually and as the president of the Malvern Hills Neighborhood Association, so I just, for the record.
That's correct. The Malvern Hills Homeowner Association does in fact have standing as well.
Sorry, Mr. Chair. We have no objection to them proceeding with trying to establish standing for Mr. Corpening, is that right?
Correct.
Ms. Corpening. I don't expect to engage in a long cross-examination like I did last time, but we think that the foundation for that ought to be before the board.
Fair enough. Okay. If you'd like to go ahead and do that now, I'm going to remind everyone and request everyone speak into their microphones so everyone can hear you. Getting the impression there's some community interest from the people in the room. That said, if you can't hear someone, if you don't mind raising your hand, anytime we hear words, it's hard to overhear 2 things, and I hate to miss any information from either side. If you'd like
Thank
to
you,
go
Mr.
ahead,
Chair.
Knorr.
At this point, we would call Bennett Corpening to testify. Mr. Corpening? And just for housekeeping purposes, does staff have a preference on where we start the numbering of the exhibits? I know at the last hearing, we had a certain number of exhibits. I don't want to confuse anything.
We would prefer that any additional exhibits start at the letter C.
C, okay.
If we could start by swearing him in.
Raise your right hand. State your name.
Bennett Corpening.
Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Good afternoon, Mr. Corpening. Can you tell us where you live?
My mother's house is the one in question. The address is 152 Shelburne Road, Asheville.
And what's the proximity of your mother's house at 152 Shelburne to the proposed development?
It's uniquely very close to the creek. It's probably 200 yards from the development.
So is it right across from Hominy Creek from the development?
It's halfway down the hill, so it's not on the creek, but it's halfway down the hill to the creek.
And did you prepare an affidavit in support of your request for standing in this case?
Yes, it was passed out at your last meeting.
And you said starting at C, staff, or starting with D?
Well, Mr. Corpening's submittal is B.
I'm going to hand you what is marked as Exhibit B, Mr. Corpening. Can you identify what this document is listed as Exhibit B?
Yes.
And what is that?
It's my affidavit that I had signed and notarized.
And I realize that's already been admitted into evidence, but we wanted that identified for the board as well. In that affidavit, can you talk about the relationship you have? It's your mother's property. Can you tell us what authority you have to speak on her behalf today?
I have power of attorney, and that was attached to the affidavit handed out last month.
And have you reviewed the application and site plans for the proposed development?
I have.
And what have you, after reviewing those, the application and site plans, what impact do you believe that development will have on your mother's property?
Well, based on the affidavit, the house owned by my mother is going to be below the 4-story structure that's going to be built. So in essence, we'll be looking west right at the side of the building, and it would block the view of Mount Pisgah.
So at this present, currently the home has a view of Mount Pisgah looking out way over towards the proposed development, correct?
Looking west, that's correct.
Okay. And when you looked at the development, if I'm summarizing your testimony correct, your concern is the loss of your viewscape and the elimination of the view that you have and the impact that would have on your property value.
Yes, that's correct.
Okay. And when you looked through the application, did you look at the siting of the buildings to determine whether this would have an impact on your property?
Yes.
What about the height of the buildings?
4 stories, yes.
Okay. Was there anything else you considered in developing your opinion about the impact of the property?
Nothing that I added to the affidavit.
Okay. At this point, I don't have any further questions for the witness.
I don't have any questions for the witness, but I do have a couple of remarks I'd like to make to address to the board.
A couple of what, I'm sorry?
A couple of remarks that I need to address to the board.
So I'm happy to let you do that in one moment. I was going to give him a chance to summarize prior to. If you don't mind, Mr. Knorr, you can make your argument.
To summarize the basis for Mr. Corpening's standing, or I should say Mrs. Corpening's standing, it's based on the loss of viewscape and the view of Mount Pisgah and the impact that will have on the fair market value of Mr. or Mrs. Corpening's property. I'd offer in support of that a case titled Sanchez versus Town of Beaufort. This is from the North Carolina Court of Appeals from 2011, in which the Court of Appeals found that the loss of a viewscape is sufficient to establish standing in cases like this. In the Beaufort case, the situation dealt with a home that was looking out over the sound, and the proposed development would be placed between the home and the sound and eliminate that viewscape, and the court found that standing was present in that case. I'd offer that up.
You can hand that, I guess, the staff first, and I'm sure we'd all like to take a look.
And as was the case at the last hearing, at this point, it's allegations-based. These are our allegations related to standing, and we would obviously need to prove those allegations through the testimony that we offer in the hearing today.
And we will note that all of the discussion and testimony offered presently is solely for the purpose of standing, not substantively as to the project. Thank you.
Yeah, thank you, Mr. Chairman. And the only comment I'd make to that is that a view of Mount Pisgah or any mountain in and around the Asheville area does not establish standing. And this case involving the town of Beaufort, the situation there was that it was in a historic district, and there was without going through the case in detail, there were some very specific requirements in that case that form the basis of the board's that form the basis of the finding of standing in that case. So, but I would submit to you that a view of Mount Pisgah, unless you've got an easement, and I haven't heard that they do, that does not establish standing.
If I may respond, Mr. Chairman,
In
briefly.
one moment, do you have extra copies of the case so we can all?
I have 2 extra copies. Excuse me, 1 additional.
Mr. Chair, we can run additional copies if the board so pleases.
If anyone else has interest, I just want to look over it briefly.
Pass that along, could you?
Yeah.
I have 1 additional I can bring.
If you don't mind, I'm going to read this while you respond to that. I'm going to give him adequate opportunity, and you as well. Please go ahead, Mr. Knorr.
Our response to that would be is that the distinction, my understanding of the case, is not that the court held that because it was in a historic district that gave it standing. Again, I think we have to think about what standing is. Standing is, are you the right person to come through the door and complain about this project or critique it? And so what the court found is that an allegation, in that case, the loss of a view, that resulted in a reduction in the property value was sufficient to show injury, and that gives you standing. In this case, we have the same thing. We have a view of Mount Pisgah. That view will be lost. That's the allegation. And we have expert test. And again, at this point, it's the allegation. All we have to do is allege sufficient facts to get through the door. We then have to prove that they are correct during the hearing. And we have an expert witness who is here who will testify to that effect during the hearing.
And Mr. Chairman, to respond to that, yeah, I've heard nothing in what either the witness or Mr. Noor has said that suggests that this particular person is going to suffer special damages separate and apart from the community at large as a result of this of this project. I just, you know, a view of the mountains is something that everyone in Buncombe County and Western North Carolina experiences. It's just, and a project that obstructs that view is not sufficient to confer standing.
I would just briefly respond with, I live in East Asheville and Hall Creek. I don't have a view of the mountains. Not every property does. In fact, they're marketed for sale when they do have views. And so that's what makes those properties unique, and that's why they sell for more, usually, with a view than without one.
Thank you. Mr. Freeman, if you'd like to weigh in, or Mr. Frew, you may. And
Mr. Chairman, I'm not going to have time to fully evaluate this case, but it does seem to me that it would be within the purview of this board, based on the discussions of the attorneys of record, for this board to decide whether or not this person has standing based on the evidence presented.
Any further argument before the board takes a second to deliberate on this?
I would just point the board to, this is page 5 in the opinion, and I'm reading from it. She also alleged, and I'm quoting, she also alleged that its proposed height, Smith's nonconforming structure, would interfere with her use of the property by causing her to use her private waterfront view. Both petitioner and her husband asserted during the hearings that Smith's application that the loss of the view would reduce the value of the petitioner's property by at least $100,000. Treating petitioner's allegations as true and viewing the supporting record in the light most favorable to the petitioner, she has established the special damages necessary to confer standing. That's the holding of the court.
I'll give you a chance to respond to that if you like.
Again, Mr. Chairman and members of the board, the Sanchez case was in the context of a historic district in the town of Beaufort, and one of the things they look at is under the law, the enabling legislation for historic commissions is whether the the change would be incongruous with the special character of the landmark or district. And in this case, we're not talking about a special landmark or district. So I'd submit to you that that what they've alleged is not sufficient to establish standing.
I would agree with you that the case addresses a specific situation. In what case would you say that an obstruction of a view would not allow someone to assert standing or special damages on that basis? Are you saying that it's never, obstruction of view is never a basis for standing, or just in this particular case?
Well, clearly obstruction of a view is sometimes, or can be sometimes, the basis for an assertion of standing. But in a situation like that, I think there needs to be, that it needs to be established that there are regulations, as in the case of a historic district, or laws that guarantee access to that view or prescribe for access to that view, or that otherwise limit the height of structures.
If I may, Mr. Chair, I think conceding the point that it can be answers the question. We've alleged that it has. What we have to do is then prove it during the hearing. So that goes to the weight of the evidence on whether we have standing versus whether we've alleged it sufficiently to step through the door, and I think we have.
Thank you both. I'll accept any board input at this time.
Call the question. I'm prepared to make a motion.
Please.
I'd like to make a motion to accept
Jesse Corpening.
Jesse Corpening as having standing.
Just as a housekeeping matter, you're asserting that he has standing, not his mother?
I am asserting that his mother does as the property owner, and that Mr. Corpening, as the power of attorney, is here on her behalf representing her interest in providing testimony on behalf of Ms. Corpening. As you'll recall, Ms. Corpening cannot physically be here.
Technically, can we amend, or I guess withdraw that motion and I guess say for the mother with him standing in his stead, or her stead?
That's fine with the mother, with the representative with power of attorney.
Second.
I have a motion and a second to make a determination that Ms. Corpening has standing. All in favor?
Aye.
Aye.
Any opposed? Thank you. Let the record reflect that she does have standing. Please, no outbursts, please. All right. Any other additional matters prior to us beginning the hearing? Seeing none. Mr. Freeman, if you don't mind introducing the project.
Yes, sir. Okay. All right, so this begins the public hearing for zoning public hearing 2019-44, which is the Crossroads Planned Unit Development. The applicant in this case is Catalyst Capital Partners. The owners of the property are Crossroads Assembly of God and Gateway AVL LLC. Address of the site is 20 South Bear Creek Road. Let me state for the record that this public hearing was properly noticed in accordance with the North Carolina General Statutes and Buncombe County Code, and staff respectfully requests that the board accept staff's documentation as well as the applicant's documents into the record as evidence. Just a brief primer on the site. I think we're all pretty well familiar with it. And I do want to apologize to the board and to the public. The screen is a little washed out just because of the way we were having to move the data through the system to get it to your eyes. So I apologize for that. And I'll try to stop and explain something if you have questions about what it is you're seeing. So project site, it's located off South Bear Creek Road, just above Interstate 240/I-26. Hominy Creek skirts the perimeter of the property to the north and to the east, I believe. This is just a quick view of the site plan as submitted by the applicant. There are approximately 20 structures proposed on the site, excluding some small accessory structures, an internal circulation road, 2 access points off South Bear Creek Road, and a mixture of residential and commercial uses. This is a summary of the land use proposal as it stands at the moment. This is the most recent, as clarified by the applicant following the previous board meeting. So there are 802 multifamily residential units, 14,400 square feet of retail space, 50,000 square feet of office space, 64,000 square feet of self-storage space. The overall project density for the residential units is 11.8 units per acre out of a total allowable density of 12 units per acre. Again, just to be clear, there was some confusion at the last meeting as to what precisely the applicant's proposing. The applicant did submit a memo. It's in the board's packet. It looks like the memo that you can kind of see to your left on the screen. Again, 802 multifamily units, 14,400 square feet of retail space, 50,400 square feet of office space, and 64,000 square feet of self-storage. Yes. Okay. So I just want to be clear that that is what's being proposed by the applicant, and the applicant has asserted, and I'll defer to them in their testimony, that the traffic study has been adjusted accordingly. Let me give you a little bit of background, and this is more for the public's benefit, as to why we're here and how this process works. But the chair and Mr. Pennington have touched on this. I want to kind of give a little bit of a policy perspective on it as well. So all local governments in North Carolina, by and large, there are some exceptions, have what's called a land use plan. Buncombe County's land use plan was adopted in 1998 and was updated in 2013 through a public process that culminated in the Board of Commissioners adopting the Buncombe County land use plan. The land use plan is not law, it's policy. It's a policy document that provides a framework for making decisions pertaining to land use, transportation, housing, utilities, economic development, and other related decisions. It is the primary document that the elected body uses to make decisions about land use. And this document is hopefully going to be updated in the coming future, but for now, the 2013 plan is our document that we use in making most land use decisions at the policy level. In this case, it provides specific guidance as to the appropriate location of land uses based on constraints. So it provides guidance as to where commercial uses should be located in relationship to steep slopes, where residential uses should be located in relationship to utilities, and so on and so forth. That policy document is then it is interpreted and implemented by the county's land use regulations, the most prominent being the zoning ordinance, which was adopted in 2009. So basically, the Board of Commissioners, they take their policy as crafted in their land use plan, and then they develop a set of tools to make that happen, which they codify in their zoning ordinance. And there are other regulations that relate to that as well: floodplain, subdivision, stormwater erosion, property addressing, and so on. So you have policy. You have land use guidance in that policy. You have zoning regulations that implement that policy. Within the zoning ordinance, 12 districts are established and then within those districts, the zoning ordinance identifies what uses of land are allowable in what zoning districts. That zoning ordinance is also accompanied by a zoning map, which is also a law adopted by the Board of Commissioners that creates a visual representation of where the zoning districts are located in the county. Again, the zoning map and the zoning ordinance are predicated on the land use plan. In the case of the Crossroads property, it is on public services, and as you'll see on this graphic, the planned unit development, which is what is being proposed, is an allowable use in the public services zoning district. So, and as you'll also see on the screen, it's kind of highlighted in yellow. On the horizontal axis, public services is listed at the top as a zoning district. Lower on the matrix, planned unit developments is shown as listed. You match those two columns and rows up, and you get a C highlighted in yellow. C means conditional use. And so what that means is that a planned unit development is permitted as a conditional use in public services zoning district. So let's talk about what a conditional use is. A conditional use means a use which is permitted after review by the Board of Adjustment and found to meet the specific conditions and procedures set forth in the ordinance. Conditional uses would not be appropriate without restriction, but could be acceptable if controlled as to the number, area, location in relation to the neighborhood. Such uses may be permitted if the provisions of the county code are met. So, in short, what that means is a conditional use is allowable in a particular location. That decision was made by the Board of Commissioners when they wrote the zoning ordinance. It's the job of the Board of Adjustment to look at the particular proposal in the particular location in the particular context, subject to the regulations laid out in the ordinance, and make a decision on a case-by-case basis. But fundamentally, the use is allowed, provided it can meet the baseline requirements and satisfy any outlier issues that may derive from the particular site. A conditional use permit is not an opportunity to change the zoning district or change the allowable uses. Again, planned unit development's allowed in the PS district. This board has no authority to change that law. They can only administer the law as presented and under the standards provided by the Board of Commissioners. It's not an opportunity to create new standards. By that I mean if the applicant meets all of the standards of the ordinance and can satisfy all of the findings of fact that the board must come to in the process provided to them, then the board is obligated essentially to approve the project. And this decision is not based on public opinion. Testimony, as has already been stated, has to be competent, substantial, material, evidence offered under oath. This is unfortunately, for better or worse, I should say, not an opportunity to debate the merits of the current law. This is an opportunity to review a particular project in the context of the current law. All right, drilling down a bit more, planned unit development is any development where there's more than 4 principal structures on the same piece of property and/or any given structure larger than 25,000 square feet and/or any grouping of 8 or more residential units on the same property. And this project fits all 3 of those ways of identifying a planned unit development. There are approximately 20 structures on the site, and I believe at least one of them will exceed 25,000. And if I'm wrong about that, I'm sure I'll be corrected. The purpose of the planned unit development, so a planned unit development is a use of land permitted in the district, and it's also a process. It's both a use of land and a process. The purpose of the process is to afford substantial advantages for greater flexibility and improved marketability through the benefits of efficiency, which permit flexibility in building siting, the mixture of housing types, land uses, so on and so forth. So it's, in a sense, a way of putting aside the routine standards of the ordinance that deal with lot sizes and setbacks and allow a developer the flexibility to come up with proposals that may not meet the routine standards, but yet meet the baseline spirit and intent and purpose of the ordinance in the district that they're proposing their project within. And I'm going to go through some of the standards. I'm going to try to make this fairly quick, but board, please stop me if you have any questions about any of these points. So we're going to talk about the procedure for obtaining a conditional use permit and a planned unit development. In general, the Board of Adjustment may designate conditions that'll ensure that any given project is meeting the spirit and intent of the ordinance. The board has to come to findings of fact, written findings of fact, affirming that the standards of the ordinance and the findings laid out in the ordinance have been satisfied by the applicant. Some very general standards, and these are not standards that staff really can evaluate. This is why the board is here, to evaluate these very general findings. One, that the project will not adversely affect health and safety of persons residing or working in the neighborhood. Number two, that the project won't be detrimental to the public welfare or property or public improvements in the neighborhood. And number three, that the project will not have adverse effects on surrounding properties due to noise, vibration, odor, and glare. Again, the burden of proof is on the applicant to prove to the board that these findings have been satisfied through the design of their project. And the board has to come to that decision in the affirmative before the project can be approved. And as you'll hear as I move through my presentation and then in the subsequent discussion, staff is suggesting a number of conditions of approval that we feel would be necessary for the board to come to that finding. Key points here, ingress and egress has to be appropriately designed. In this case, the applicant is proposing a loop road, 2 points of ingress and egress off South Bear Creek Road. Staff is of the position that if not addressed, the traffic from this project would have a potentially detrimental impact on the Wendover, Bear Creek, Sand Hill Road, and South Bear Creek, Sand Hill Road intersections. As a way of addressing that concern, staff has suggested that the applicant provide a signal at that intersection subject to NCDOT approval. Staff is also suggesting that the applicant commit to constructing a greenway segment on the applicant's property in furtherance of the Buncombe County Greenway Master Plan. The applicant has proposed a number of turn lanes into the property from South Bear Creek Road. And assuming this project gets approved, which it may or may not, the applicant, if approved, would have to secure an NCDOT driveway permit that satisfies all of the board's requirements, DOT's requirements, and the applicant's own proposals in their master plan. Parking, the applicant is proposing 1.67 parking spaces per dwelling unit. The ordinance minimum is 1.75. The Board of Adjustment has the authority to approve lower parking thresholds below that 1.75 through the planned unit development process. And in this case, the applicant is proposing to share parking across different buildings and different uses in an effort to reduce the total amount of parking being provided on the site and therefore reduce some of the impervious surface areas and potential stormwater impacts to the site. Otherwise, the applicant is proposing to meet the minimum 1 space per 300 square feet of retail space and office space. So 1.67 units parking spaces proposed per dwelling, 1.75 is our starting point. The board has the authority to approve the 1.67 if it so chooses. Utilities, City of Asheville Water and Metropolitan Sewage District sewer allocations have been provided. Buffering, no clear buffering was shown on the site plan. Let me say that a different way. The site plan, the color version of the site plan, which the applicant will show you in a moment, which I briefly showed you at the beginning of my presentation, does show vegetation. Staff recommends as a condition of approval, if the board chooses to approve the project, that a landscaping and buffering plan be provided for each phase of the project as it comes in for zoning and construction approval by the planning department and the building inspections department. Signage, the applicant is not proposing any signs at the present time. Any future signs would have to meet minimum standards of the ordinance. In terms of playgrounds, the location and sizes of buildings, hours of operation, things like that, staff would just stipulate to the site plan. Hours of operation really aren't particularly relevant to this type of project. Playgrounds, open spaces, yards, those are all shown as such as they're proposed on the site plan. So would direct your attention to that plan. Ownership and control, the applicant proposes to maintain ownership and control until such time as any future subdivision activities occur. So at this point in time, they're in compliance with the ordinance. Density requirements, the proposed density as reflected on the site plan for the project is 11.8 dwelling units per acre. The maximum allowable under the ordinance is 12 dwelling units per acre. So the applicant's proposal in terms of overall density is compliant. Land uses, and it's a little hard to see on that screen, but again, I've already summarized the proposed land use composition: 802 multifamily units, 14,000 square feet of retail, 50,000 office, 64,000 self-storage. The applicant has also submitted a more detailed land use breakdown that we would use for permitting purposes if the project is ever approved. That is attached to the applicant's proffered conditions of approval as Exhibit B. I'd be happy to pull that up and go through it with you if you want, but suffice it to say that what the applicant is proposing is consistent with uses permissible in the Public Services District, as well as the Neighborhood Services Zoning District, which is the county's sort of lowest intensity commercial district. So in terms of proposed land uses, there's nothing in particular that stands out to staff as a problem as far as what might happen after this project is approved, if approved, when it comes to actual site-specific zoning permits. The applicant complies with all of the baseline setback requirements for side, rear, and front property boundaries. The applicant complies with the 20-foot separation between buildings as required. The applicant is proposing an 8-inch exception to the 50-foot height limit. Again, the board has the authority to approve that based upon the applicant's presentation and the board's preferences. So if the project is approved as it's presented, you would be approving an 8-inch deviation from the 50-foot maximum height limit. Privacy, I think that relates back to buffers and screening. Again, staff is suggesting that a condition of approval might be for the applicant to submit landscape plans along with each phase of development in the future. That landscape plan, if it provides adequate buffering and screening around the perimeter of the site, should help assure privacy to the neighbors. Perimeter requirements, the site plan does meet all of the perimeter requirements of the ordinance. Okay, so that is a quick and dirty summary of the project. Overall, the application is completely compliant with the dimensional and land use and physical requirements of your ordinance pertaining to height, setbacks, building separation, composition of land uses, the exception being the 8-inch, a request for an 8-inch deviation from the 50-foot height limit. Those are kind of the simple, easy issues for us to tackle. You'll hear during the testimony from the audience and from the applicant more complicated issues like traffic. Staff will reserve comment on those issues until we get into those specific discussions, unless you have any particular questions. So to close out my presentation, the Board of Adjustment has to come to a finding of fact that the applicant has satisfied all of the explicit requirements of the ordinance, as well as address the more general health, safety, and welfare type findings that are provided in the ordinance. The applicant has the burden of proof to prove that he has or they have addressed those findings of fact sufficiently for the board to find in the affirmative on each point. Once the applicant has made a case, the burden of proof in a sense shifts to the opponents to dispute any points made by the applicant. In other words, the burden of proof shifts to the neighbors to allege that sufficient evidence was not submitted for the board to find affirmatively on those findings of fact. Apologize, I'm stumbling. The board, just to draw your attention to the findings of fact worksheet that's in your packet, it's the standard worksheet that you typically receive. I'd be happy to answer any questions about that if you have any. Staff comments as far as the bigger picture is concerned, we've already expressed concerns that we have about traffic, particularly on the aforementioned intersections, and you'll see in the applicant's proposed conditions that they are willing to address that. We'll leave it to the board to decide whether that's sufficient and how to move forward with that. Just to point out, there are significant portions of the site that are in the 100-year floodplain. Staff would suggest that conditions need to be attached to any approval to address how the floodplain is handled in future permitting post PUD approval. Just to point out, there is a significant wetland area that's being proposed for disturbance. I've already mentioned the need for some landscaping and buffering, which can be addressed in the subsequent permitting process for each phase. And staff's already mentioned, as suggested, the applicant to be required to contribute to implementation of the Buncombe County Greenway Master Plan. And just a quick view of that, you can see this is hard to see on that screen, but the Buncombe County Greenway Master Plan does show a section of a new Hominy Creek Greenway segment going through the property. I believe the applicant is committed to participating in that as part of their offered conditions, but again, we'll come back to that at a later point in the discussion. All right, last, just to close out here, conditions of approval. I've talked a lot about that in this presentation. The applicant has submitted proposed conditions of approval to address many of the concerns that have been raised either by the public or by staff or even by the board in prior discussions. Those conditions reflect the minimum necessary for staff to be supportive and suggest approval of the project. However, those suggested conditions as proffered by the applicant are a starting point for conversation. The board is in no way, shape, or form limited by what the applicant has presented or what staff has suggested, and is not committed to those. The board has to come to its own findings for this process and come to its own perspective on whether to approve the project, deny the project, approve it with conditions, and approve with what conditions. We have simply provided what the applicant has submitted as a way of expediting that conversation and getting it started, and you're not limited to what's been presented. The board may accept, modify, delete, add additional conditions. It should be clear, though, that the applicant has to be willing to accept any conditions that the board puts forward. If the applicant is unwilling to accept a condition that you might suggest, the board then must either deny the project or approve it without that condition. Everyone has to be in agreement, or we move forward without the condition, or we deny the project. In closing, the board's options: approve the project as presented, approve with conditions, deny as presented, and you may find a reason to continue to a date certain at the end of today's discussion. It's an option you have before you. And I'll take any questions.
Chair Moore, just wanted to point out that the NCDOT is here. You may want to hear on that segment first, just because the DOT had mentioned to staff earlier that they have some other things to attend to this afternoon. Just wanted to put that out there for you.
And just so the attorneys know, my strong preference would be for that, so we can get the expert testimony out there and address whatever concerns we need to while we have them, and avoid continuing this for round 3 in the 2020. Okay. Any questions for staff?
I have a question for staff. You noted that it was only an 8-inch. Microphone. I'm sorry. Can you hear me now? Can you hear me now?
And Mr. Chairman and the board, I just want to point out that the information provided by staff on this presentation is for information only for the board and for the audience here. The burden of proof is still on the applicant and shifts. So this is information only, so you can't make any comments on that, and I will just leave it at that for now.
Thank you.
Thank you, Mr. Freer. All right.
Take a small break before we start the DOT.
I'll hear from the board.
15 in.
Is everyone in concurrence with that? Do we need a break at this point?
Small break.
I'm fine.
I'm okay.
Okay.
Yeah. Let it rip.
All right, just out of the interest of getting the DOT portion done, let's see if we can power through that. In our discretion, we'll go ahead and admit the staff report, and thank you for your notations. And if the applicant would like to begin, preferably with DOT, you do not have to, but if you're not, please let me know that now.
We have a certain process here for our presentation. I'm not sure exactly. Could we talk about it just a second to see how we might accommodate that?
Please. And while they do that, are the DOT people actually in the room at this moment? We have you guys for at least another 30 minutes? Okay. Yes, sir.
I was just going to ask how long they would be able to stay. We could get to them as quickly as possible, but to just throw them up here is
No, I'm not
gonna
going to
work
dictate
well.
your presentation. I just
Yeah.
wanted for all parties involved to know if
Okay.
you lose the OT, they're not coming back, is my impression.
Do we know how long they could remain?
If you guys can stand up for me. About how long, sir?
We can stay till 3.
Okay, great. That should be plenty. I think that should be plenty of time, don't you think? Yeah, when we can focus there first when we get into that. So thank you, Mr. Chairman.
Absolutely. Proceed at your leisure.
Thank you, Mr. Chairman, members of the Buncombe County Board of Adjustment. My name is Lou Bissett, and I, along with my colleague Bob Ost, represent the developers of the Crossroads project. The developers are here, and you will hear from some of those during our presentation. Bo McIntosh and A.J. Klink of Catalyst Capital Partners. Todd Jakovic is here from Stonehenge Real Estate Group. These are quality developers, and you will see some of their projects in the presentation a little later. In addition to the developers, we have a number of consultants present from our development team. Chris Day, Patrick Bradshaw, and Warren Sugg from Civil Design Concepts, Richard Petersheim from Land Design, Jason Gilliland, Nature Trail and Greenway Consultant, and Jeff Moore and Lance Hartland, traffic engineers with Mattern and Craig. So before we begin our detailed presentation, I'd like to make a few general comments related to the property, the project, and why we think at the end of this public hearing you should grant zoning approval for this PUD. The property consists of 68 acres that it's zoned public services. The property is served by public water and sewer, and as you know, is adjacent to I-240. Public service zoning includes a number of permitted uses. They include retail, breweries, hospitals, hotels, public utility stations, schools, theaters, restaurants, bars, vacation rentals, healthcare facilities, single-family subdivisions, multifamily housing, and on and on. So there's a wide variety of both residential and commercial uses in the public service zoning. The public service district, as Josh indicated, allows 12 units per acre. And I would just point out that adjacent city zoning districts allow, for example, their RM6 district, which is adjacent to this property, allows up to 39 units per acre, and their RM8 zoning district, which is also adjacent, allows up to 41 units per acre. Now, I don't think I'll get much of a disagreement from people here or anywhere in our community that we have a dire need of additional housing in Buncombe County. I saw some numbers just yesterday that said of the people who come to work every day in Buncombe County, 40% of them commute in from other counties. And they do that primarily because of a lack of adequate housing in our county.
Ladies and gentlemen, please, in the best interest of moving through this in probably fewer than 5 hours, please, we save it for when we get to the public comment phase. I promise everyone's going to get an opportunity to speak if they want to. Is that fair?
Thank you, Mr. Chairman. The project includes mid-rise apartment units, senior housing units, neighborhood retail, an office building, and a self-storage facility. And I want you to know that this project is not going to be built out there in the next 4 months. It's actually going to be phased in over a 3 to 10 year period. So I think everybody ought to keep that in mind. This project provides a high quality, broad range of multifamily housing options, including, as I indicated, much needed senior housing. And I think this project addresses our community's #1 issue, adequate and affordable housing. Project also includes national green building standards for all structures. All of the proposed uses and the requested density are fully allowed in the Public Service District. Let me just for a second review the community impacts and our developers' efforts to integrate the project into the community. Now, Crossroads Church was mentioned. Crossroads Church has been located in West Asheville since the 1950s. The church as a part of this process, vetted a number of developers for this property and approved this developer's plans because this project meets a serious community need and at the same time treats the property with respect and environmental sensitivity, and in effect would institute what they look at as a neighborhood village.
Mr. Chair, I hate to object in the beginning, but I didn't hear in the list of individuals that Mr. Bissett provided that a representative from the church was going to be testifying, and so I want to make sure that evidence isn't being presented that won't.
I think there will be a representative from the church testifying. I'm sorry, he's not, he's separate from our team, but he will be testifying.
Thank you.
Okay, thank you. I also want to point out the high level of community outreach that our developers have tried to engage in. They've had over 45 meetings over the past year with numerous stakeholders: Buncombe County Planning, Parks and Rec, the NCDOT, the city traffic engineers, wetlands consultants, greenway leaders, Riverlink officials, and Malvern Hills Homeowners Association representatives, together with hundreds of interested citizens. Conservation efforts have been significant and varied. Only 41 acres under this PUD, only 41 acres of the 68 acres will be disturbed on the site. And I think you'll find from our presentation that there is highly sensitive placement of the buildings away from Hominy Creek and carefully sited on the property to respect the topography and neighboring property owners. I think the county required setback for buildings from Hominy Creek is 30 feet. I think the closest building in this PUD, and you'll see this later in the detailed site plan, the closest building to the creek is 265 feet from the creek. They've also included a 1 mile long greenway along Hominy Creek and have committed to its integration into the existing public greenway system that adjoins it. They've also committed to significant traffic improvements for the neighborhood, turn lanes to be installed for ingress and egress to and from the project, and signalization at the intersections of South Bear Creek, Sand Hill, Windover, and Bear Creek, all to be installed by the developer. In addition, pedestrian crossings to be installed at the above referenced signalized intersections by the developer, and we'll give you a lot more detail on that later. Keep in mind that these traffic improvements will be installed on the front end of the project and will significantly improve existing traffic flow over and above any later project impact. And remember again that this project is to be phased in over a 3 to 10 year period. Before I introduce my colleague Bob Oast to discuss the hearing process and before we begin our detailed presentation of the project, I would like to make one final point, particularly for the concerned neighbors who are here today. Under current zoning, a developer could, as a matter of right, construct a wide range of residential structures and commercial facilities on the property, utilizing a much larger percentage of the 68 acres and without providing for a public greenway and other amenities. Such developments could by necessity include significantly more grading and the installation of numerous impervious roads and driveways. They could also increase substantially the number of daily trips onto existing public roadways. And I would like for you to remember, and I'd like for our community neighbors to remember that one of the most important things that the community gets from the approval of this PUD is certainty about exactly what will be constructed on the property and where. If approved, this site plan will be etched in stone and cannot be materially changed without the approval of this board. The Crossroads at West Asheville is a high-quality development which meets many extremely important housing needs of our county, and it does so through a sensitive, phased, and neighborhood-friendly plan, which has been developed over the course of a year utilizing a significant amount of community input. I would like to now ask Bob Oast to discuss the process and begin our presentation of the project. We intend to present competent material and substantial evidence as to this project's compliance with each of the general and specific standards set out in the Buncombe County zoning ordinances. Thank you very much for your attention, and I'll ask Bob to take over. Thanks again.
Thank you. Mr. Chairman and members of the board, my name is Bob Oast. I'm here representing the applicant, Catalyst Capital Partners, and we're here for a conditional use permit to allow for a planned unit development 1 as it's defined in the county code for 68 acres on South Bear Creek Road. It's known as the Crossroads at West Asheville. The property is currently zoned public services, which permits a broad range of uses, both residential and commercial. Catalyst proposes a mixed-use planned unit development. It's primarily residential, and it's within the densities allowed by the code, with some commercial uses also proposed. The county ordinance requires a conditional use permit for this mixed-use project. Under the county code, it's a PUD 1 because of the residential component. The purpose and the purpose statement for the PUD 1 is that it says that this section is to afford substantial advantages for greater flexibility and improved marketability through the benefits of efficiency, which permit flexibility in building siting, mixtures of housing types, and land use. Residential densities are calculated on a project basis, thus allowing the clustering of buildings, which we plan to do, in order to create useful open spaces and preserve natural site features. In order to obtain a conditional use permit, the applicant must, and this, I'm repeating some of what Mr. Freeman's already covered, the applicant must satisfy the applicable standards set out in the county code for all conditional use permits. These are the general standards. In addition, there are several specific standards. There are several standards that apply specifically to planned unit developments, and those are I'll refer to as specific standards. I'm not going to recite those standards here, but I will note that some of them are objective and quantifiable and as easy to satisfy as sometimes just checking a box. Others require more deliberation. The Board of Adjustment's findings as to all standards must be based on competent material and substantial evidence. Some of that evidence can only come from qualified experts. This is a statutory requirement. We have witnesses here who we expect to qualify as experts. The manner of presentation that we'd like to do is to have our team present their do their presentation and as we do that, as each member of our team comes up, I will ask that member a few questions to the extent necessary to qualify them as expert witnesses. We've got engineers, appraisers, traffic engineers, and they need to. I need to qualify them as experts in order for the testimony to be competent. But I plan to let them do most of the talking and be available for questions. Now, with the board's indulgence, Mr. Noor and I have talked about this. Rather than pausing at the end of each witness's testimony to allow him the opportunity to cross-examine, what we'd like to do is proceed through our presentation and then allow him to ask the questions of the witnesses as he wishes. And the same thing for our questioning of their witnesses. And I know that's not the normal process, but I think that would make the presentations go smoother, perhaps take up a little less time. And with the board's indulgence, that's the process we'd like to follow.
I don't believe anyone on this board would have any objection to. Microphone. Thank you. Am I loud enough now? I've never been accused of being quiet, so this will be a difference. I have no objection to, if you both consent, modifying it so long as it remains within the realm of constitutional and valid. And of course, that means you waive any objection to procedure on that, but.
I think will be within the realm of constitutionality. Before we get started, I want
Just quickly for the record, we do consent to that structure. We are reserving our right to cross-examine the witness after the presentation and to make objections throughout the presentation if they are appropriate.
This is a public hearing, and of course, members of the public will speak. It's also a quasi-judicial hearing, but it's not court, and not everyone is represented. Because I've been in a number of these hearings, I anticipate that some of what the speakers say may be subject to objection. There's some things, for instance, testimony that should only come from an expert that I don't have to object to in order for it to not be considered. But there may be some things I have to object to. I'd prefer to address these issues in rebuttal if possible. If I have to object to something, I will wait until the speakers finish rather than interrupt them. And with the board's permission, I may make a blanket objection if we keep hearing repetitive testimony that may not be competent. Before we get started, I want to hand out our presentation, this presentation contains a slideshow that you all will see, a fact sheet. Sorry. It contains a slideshow presentation that you all will see displayed up there. It contains a summary prepared by one of the members of Catalyst Capital. It also contains some letters, some of which you all have been directed to the county, and we think that these folks are here. In fact, we know that some of them are. We think that all of them are. There's a short memorandum of law from me, a copy of the conditions that we have signed and offered to the county. So I'll hand these folders out to you. It's got a copy for the.
If I could see a copy of that, we would register an objection as to the letters if they are unsworn, and request that if those. Our objection, I'll repeat. We would raise an objection as to the letters if they are unsworn as a baseline, and in addition to that, would prefer that if those individuals are here, they need to testify rather than submit those letters to the board. We also think that there's a relevancy issue. I haven't seen these letters yet, so I don't know what issues, whether that relate to the standards the board has to consider or not, or whether they're just general, I support this project. Obviously, the I support this project letters wouldn't be relevant to the board's determination, but letters concerning particular standards would. So again, if they're unsworn, we would object, and we'd prefer that the testimony be given live.
I think for both sides, can we all agree that we can't really make a determination about admissibility until we have a chance to see it, until we actually know who's here, who's not, and what the contents of the letter are? I suppose I'd reserve judgment on it until the appropriate time that we have it before us.
And we just ask the board not to look at it until that moment as well, if it's going to be handed up to you for consideration.
Any of it, or?
No, just the letters.
Okay. We'd have to look at the letters to determine whether or not they're admissible, but we can give it the appropriate weight once we figure out what it is. If you don't mind approaching and handing those, I guess staff needs a copy first.
Mr. Chair and Mr. Ost and Mr. Noor, I'd also make a suggestion in terms of swearing in so since there are going to be a number of people speaking, maybe it might be appropriate to go ahead and swear in your experts first, whether that be in some sort of huddle or whether that be individually for you to decide totally. Just wanted to bring that up.
Thank you.
We also need to swear in staff.
If you want, let's address one thing at a time. If you want to swear in staff first, and then we can give the presentations to staff and go from there.
Don't swear in, Judge. Not until later. Not for that information.
You just hand it around.
Let's start this stuff.
Thank you.
Mr. Chairman?
Yes, sir.
I would make a recommendation that witnesses are sworn in prior to their testimony individually, not as a group.
Any other board thoughts on that?
I think that would eliminate any concern of who wasn't bringing a group of people up. It won't slow it down significantly, I don't think.
Mr. Chair, we're going to hold off on swearing staff until we get to that point.
That's fine. Okay. So just to make sure we get the procedure correct here, I share the concern about how we go about swearing people in. I do think individual is prudent. However, I think there can be some flexibility if we know we're going to have consecutive short testimony witnesses to one at a time and can address that and then have them come up. But we'll defer to you to the extent that it's your presentation. I'm not going to hijack your presentation here, but just keep in mind that the time concerns, I cannot make you call witnesses out of order. I don't intend to do that. But if the DOT has expressed that they're here till 3, then I'm going to ask you to consider that both sides have questions for them.
I understand, Your Honor, and we'll move as quickly as possible. And what I would suggest is that we get the members of our team that I know will present sworn in first, and then we won't have to interrupt the proceedings to get anybody else sworn in. And one other request I'd like to make is that we received some information today, only today, from counsel on the other side here, and I'd like a short break at some point. You all are probably ready for one anyhow, but a short break at some point to confer with one of our witnesses about some of the information that we got.
From opposing counsel?
Yes.
We would ask for that same opportunity because most of what's in this we have not been provided before either. So just whenever that break occurs, I think we can do that.
It seems like
there's
now would be an
information for both
appropriate
sides.
time for that, if all of you are agreeable.
Yep.
All right. What time is it now, staff? 1:38? Is that right?
Yeah.
Let's take a hard 15-minute break.